What to do when disputes are not removed. You sent your letters to the credit bureau disputing items on your credit report. 30 days later, you receive a letter from the credit reporting agency stating they have investigated your disputes and verified them as accurate. What do you do now? You move to the next phase of the removal process and request the method of verification. The Fair Credit Reporting Act states that the proper investigation involves the credit bureau having a copy of the original signed credit application in their files. This is how they're supposed to prove verification. The reality is the credit bureaus don't review any documents, let alone keep a copy of your credit application in their files. The credit bureaus send an electronic request through a system called eOscar, which electronically asks the creditor if the information reported is correct. The creditor will usually respond back with the answer, yes, it is correct. This is how the credit bureau usually verifies your information if it's true. Unfortunately, this is not the proper way to verify disputes. There must be documented proof. When this happens, you will mail the second letter that requests the credit bureau to provide the specific method of verification used to verify your dispute. The method of verification letter forces the credit bureau to prove they actually verified the hard copy account information. The method of verification letter asks the credit bureau for the name of the original creditor, the address and phone number of the original creditor, the name of the person at the credit reporting agency who verified the dispute with the original creditor, and the documentation that was used to verify the dispute. The credit reporting agency is required to give you the method of verification within 15 days of your request. You should also send in an original creditor dispute letter directly to the original creditor. Since the credit bureau stated that the dispute was verified as correct, your letter to the original creditor will ask for the proof used to verify the dispute with the credit bureau. If the original creditor cannot provide proof, you will have confirmation that the credit bureau did not use the proper method of verification. With this information in hand, you can request to have the dispute removed from your credit report. If the credit bureau responds back with anything less than the information they have used to verify your dispute, you will send the next dispute letter stating your intent to sue. This letter has a little stronger language regarding the credit bureau's willful noncompliance with the Fair Credit Reporting Act and your intent to pursue litigation. Your suit will be a civil liability for willful noncompliance. Reference the Fair Credit Reporting Act, Section 616. This section of code defines the liability for failing to comply with the law. At this point, it would be wise to contact an attorney to assist you should you decide to proceed with the suit. It is hopeful that by the time you've reached your third or fourth letter, you will have had some success with the removal of items from your credit report. If you have not reached total satisfaction with your results, there's a final letter available. This letter is a notice of pending litigation seeking relief in monetary damages under the Fair Credit Reporting Act, Section 616 and Section 617. By the time you reach this final letter, you will have exhausted your attempts to rectify the problem. The only thing left at this point is to report the matter to the Consumer Financial Protection Bureau and seek legal assistance. They can help you find an attorney that specializes in this matter. Provide the Consumer Financial Protection Bureau and your attorney with all the documents that show the actions taken to rectify the dispute. This concludes the dispute process.